another key theme that comes through the readings that you have for this week, and that we'll be talking a little bit about in the tutorial, is this idea of legal personality. So we've touched on it in the tutorials and a couple of times in these lectures, but I want to make sure that we're all on the same page, and I'm going to illustrate my thoughts about legal personality in the context of AI by looking particularly at contracts. I think that will be the best way, but we'll also talk about corporations and the ways in which an AI might become a new legal instrument in the way that term is used in the readings that you have this week. So as far as the law is concerned, a legal person is any human or thing, so less ambiguously we could call that a legal entity, that can do the things that a human person is able to do at law. So that's enter into contracts, sue and be sued in its own name, own property, whether that's intellectual property or physical property, and so on. So we've got this term legal person, and the reason for that is that some legal people are not in fact human beings. They might be companies or corporations. These are a legal fiction, really. We call them legal people because they can do the things that human beings, adult human beings, can do as a matter of law. But they're not people in the sense that human beings are people. At common law, in the common law tradition, only a person can possess human rights. And that's how, in the common law tradition, only a person can possess legal rights. And as a consequence, this is how this legal fiction has evolved. The logic kind of went, if we're going to have the right to sue and be sued and to be able to enter into transactions, the only way that something that is not a person can do that is if they're actually a person. So let's create this new category of persons. And that's effectively what a company is, a legal fiction that is separate from its shareholders and from its directors, which can own property, sue and be sued in its own name, and has a range of rights, but clearly it can't go to jail. It can't incur a physical punishment. So even though it has rights and obligations that are quite similar to those of a natural person, or I use the term organic person, it's quite different. So essentially these rules were developed to allow corporate personalities to function, and they from the very beginning had 5 essentially legal rights. The right to a common treasury, so that is the right to own property. The right to a corporate seal, as in the right to enter into contracts. We don't use corporate seals anymore, but this is really where it comes from. The right to sue and be sued, to enforce those contracts. The right to hire agents, employees, and the right to make its own bylaws, so to self-govern. So this question comes up in relation to AI. Can we think about ways that an AI that is autonomous might be something analogous to a company? And should it have legal rights and legal responsibilities that are, like a company, analogous to those of humans? This comes up largely in the context of liability, which is something we're going to talk about a lot more next week. And that's essentially the question of who foots the bill if an AI makes a mistake, causes an accident, causes damage, or somehow becomes corrupted. Is this the responsibility of the manufacturer, the developer, the person controlling it, the person who owns the machine that is using the machine being used to process it? Is it the person who gave it the instructions in the first place? Or is this a matter of allocating and apportioning risk and liability depending on what the technology is being used for? Or granting this electronic rights as such to an AI or to robots assist with answering some of these questions. We'll talk about Sophia in this section, the social robot who has been granted Saudi citizenship. Although I'm pretty sure everybody agrees that's just a marketing campaign as much as anything else. Will human actors take the giving of legal personality to AI, if that happens, as a shield, a way of getting out of making sure that the AI operates properly? Or will it provide the relief that gives them an incentive to continue investing and continue developing, the way that companies shielding shareholders from financial responsibility is basically a technology that has enhanced entrepreneurism over the years. Your readings address all of these questions and more, and I want to point out a few things to look for. It's not unheard of, in addition to the company being a type of legal person, actually, we've seen other things become legal persons too. There are two rivers in India, the Ganga and the Yamuna, that have been granted legal status. In New Zealand, legislation has been enacted to grant legal personhood to the Wangui River and Mount Taranaki, and another protected area, I'm not going to be able to say it, I'm sorry to my Kiwi friends out there, Te Urewera protected area. Until then, really, corporations were the only non-human entities recognised by the law as legal persons. But it's worth remembering too that historically, our regulatory system didn't always grant human people legal personhood. Slaves, women, children, they basically didn't have legal personality for a very long time. And so we can see that this concept, it's not a science. It is a construct that has been developed as the law has been developed. So it's absolutely possible to imagine a world where AI has legal personhood. It is worth thinking about what legal personhood means. It isn't only about liability, it's about both rights and about responsibility. Now, I think those of you who watch the videos online and you've thought about Sophia the robot, old data now, I agree. But I think we probably would agree that even if robots have some sort of concept of pleasure, pain, happiness, other emotions, that even despite the advances in effective computers, or effective computing, which enable machines to both perceive and express or mimic emotions, they don't feel emotion, they don't feel pain, they don't feel distress in the way that humans do. So putting an AI in jail or physically punishing it can't deter it from breaking laws. So if we're thinking about the use of the law to ensure that a legal entity meets its responsibility, we need to think about the moral responsibility, the extent to which compliance with the law is also an ethical duty that human actors have, because they're the ones who have ultimate moral agency and then ultimate responsibility, because they do care about punishment and reward. We've already spoken about the role of corporations as having legal personality, and that legal personhood gives those corporations certain rights and certain responsibilities, owning property, entering into contract, yada, yada, yada. If a corporation breaks the law, say by polluting a river, it can be subject to government fines or considered liable for monetary compensation to victims. Of course, those monetary punishments don't cause physical pain to a corporation, but they certainly constitute punishments, and they do have some deterrent force. the punishments deter the humans behind the corporation, the shareholders, the employees, the board of management, board of directors, from doing the things that are illegal. And in the most serious cases, the individuals themselves may be subject to civil or criminal prosecution as well. We call that piercing the veil. So particularly in relation to occupational health and safety, for example, if it is found that a company hasn't taken sufficient care and there is death or serious injury on their premises, the individuals behind the incidents that led to the company breaking that law can also be personally liable. Many people have argued that AI systems should have that kind of legal personhood. But of course, the solution is only going to work in that way if the AI and the people responsible for it, if that relationship is clearly established. If we have a risk of misplacing that moral responsibility, the causal accountability and the legal liability regarding the AI's mistakes and misuses, then we really don't have any particular link to that incentive, which then brings us back to Lessig. Maybe the traditional approach, the legal approach that we've used with companies isn't right at all. Maybe what we should be doing is ensuring that the ethical structures and compliance with the law are built into the code on the basis that machines can only do what they're programmed to do, or at least for the time being, work within the constraints that are programmed within that code, and the law becomes the code. And maybe our end result is that the people who are responsible for that AI, as in the ones who are demanding that it do things, are personally liable if it does things that result in a breach of the law. In the very long term, a lot of people believe that AIs could or even should develop full moral rights. That kind of development can help us think about what sort of deterrence would be suitable for machines, or even whether deterrent is the right question at all. Should breaches of the law result in monetary fines, jail, software deletion? Maybe we turn the machines off for all time. For the time being, however, we need to focus on the people behind AI. Well, that's my thought. The EU is leading the way on these issues. Since 2017, the European Parliament, which back then in an unprecedented show of support, adopted a resolution on civil law rules in robotics, an overwhelming majority, 396 votes to 123. One of the key recommendations, and you'll see it sort of summarised on the screen in front of you, was to call on the European Commission to explore, analyse and consider a specific legal status for robots, so that at least the most sophisticated autonomous robots could be established as having a status of electronic persons responsible for making good any damage that they cause, and possibly applying electronic personality to cases where robots make autonomous decisions. This resolution generated considerable debate and controversy because it calls for sophisticated autonomous robots to be given specific legal status as electronic people. The arguments from both sides are complex and they require fundamental shifts in legal theory and reasoning. Good fun, hey? So experts in robotics and artificial intelligence have sent the European Commission an open letter cautioning against the plans to grant robot legal status, calling them inappropriate and non-pragmatic. Your readings discuss this, the Anthony Wong one in particular, and I'll be really interested in the tutorial on your views, which side of the fence you fit on. So in the open letter, sorry, got ahead of myself here, the words in the letter, on the screen extracted from that open letter that I just mentioned. They're advocating that, sorry, this is the European Group on Ethics, Science and New Technologies, advocating that the concept of legal personhood is the ability and willingness to take and attribute moral responsibility. They say that moral responsibility should be construed in a broad sense. So it talks about causality as well as accountability, liability, reactive attitudes, including praise and blame, the appropriateness of a range of moral emotions, and duties that are associated with social roles. Moral responsibility, in whatever sense, cannot be allocated or shifted to autonomous technology in the views of this group. Anthony Wong posits, and citing many other academics in support, that the case for the electronic personhood is weak and the negatives outweigh the benefits, at least for the foreseeable future. So we can think then about the historical debates about whether or not we should be granting status, legal status to slaves, women, corporations, and then more recently to landscape and nature. We can think about how those discussions have evolved, both in the sense of the lawmakers understanding the nature of the personhood of each of those, but also as we grapple with what that personhood means. Should legal personhood for robots or autonomous systems eventuate in the future, any right invoked on behalf of robots or any obligation enforced against them is going to require completely new approaches and significant recalibration of regulatory systems. Legal personhood could potentially allow autonomous robots to own their own creations, as well as being open to liability for problems or negative outcomes that are associated with their actions. Oh, this little cartoon that I had here is, no, sorry, this is not a cartoon. This is a picture of Sophia, the robot, and basically, sorry, I should have had that on the screen when I was just talking about Anthony Wong's conclusions in the reading, because I want you to think about whether you agree that there is, in the long term, a case for electronic personhood. One of the things that's interesting about Sophia, she has honorary Saudi citizenship, but it's not at all clear what that means. It's not clear whether she can vote, whether she has similar rights to women in Saudi, which are clearly lesser rights, at this time anyway, than the rights afforded to male citizens of that country. Now, it's also worth remembering that there's always a human behind the machine. AI itself isn't a moral agent. It can't be. It's like a human, but it is not human. It's an artifact, a machine. It's been built by humans and it does what humans tell it to do. As such, if an AI commits a crime, we should primarily think of it more like a weapon than as the instigator of that crime. Or think about it as the means by which a crime was committed rather than as a criminal in its own right. And this is important if we are to hold people accountable. Of course, accountability and liability are really features of what we'll be talking about next week. So now let's just quickly move on and talk about contracts. Now, I've spoken about this in the tutorial, I know, but I think it's worth actually just doing a really high level understanding of what a contract is at common law. And this is, the law students will be all over this. Feel free to just scoot ahead if you've done contract law. But for those of you who haven't, just make sure that you're aware that contract is a very old common law device. We know what a contract is largely because of how the common law has developed over time. And there are 4 things that we need to see in order to have a contract or an agreement that is enforceable at law. That is, we need to have agreement. In other words, we need, and usually it's usually it is explained as an offer that has been accepted. But in more recent time, agreement sometimes manifests in other ways. We don't necessarily need to be able to isolate this is the offer and this is the acceptance. So parties need to have agreed something. They needed to have then intended that their agreement be legally binding. So it's not a social contract. It's not just a promise or that you'll feel bad about it if you don't do it, but it won't necessarily, you weren't expecting to go to court. It needs to have certainty. In other words, we need to be clear as to what the agreement is. Now, that means that we need to understand what the obligations of each of the parties are and what the rights are. Now, you'll notice that none of the things on the screen are written down. So unless there is a statute that says this kind of agreement needs to be written down, and there are plenty of those, basically an agreement can arise between two people or two legal people quite easily, as long as it's certain what the subject matter of the agreement is and what the obligations of the parties are going to be. And then the last one, often the trickiest one, is called consideration. Often I just refer to that as a shorthand way and call it price, but price is misleading because it makes it sound like, oh, well, that's the money. In order for a contract to be binding, what we call a bilateral contract anyway, each party needs to have an obligation, and that obligation needs to have been taken on in consideration of, in exchange for a right or a promise, something that is coming back to them or to a person that they nominate. And so if we have all of those things, then we have a contract. Like I mentioned before, statute can change that. So there is legislation that says certain types of contracts need to be in writing, in particular contracts that relate to anything to do with land. So you might have agreed with the owner of the house that you live in that you will have exclusive rights to use it for 12 months. The intention was it's a legally binding relationship. It's really clear what the property is and how much the rent is. So we've got certainty about that. We've got consideration moving from both sides. You've promised to pay the rent. The landlord has agreed to give you exclusive use of their property. But because there is a statute that says it needs to be written down, that contract, it's a real contract, won't be enforceable. Now, there are other things that can impact enforceability too, and the key one here is capacity. So when children, for example, enter into contracts, they can still be valid and binding contracts, but because the child doesn't have capacity to contract, so they don't have the legal personhood required, other than when there's a number of small exceptions, that contract won't be enforceable against the child. Similarly, somebody who is obviously drunk or in an impaired mental state, people who enter into contract with people who have an impaired ability to contract won't be able to enforce those contracts. Now, look, I've just consolidated into a tiny little bundle stuff that takes in the order of 6 to 8 weeks for students in the law school to understand. I've given you no cases and no examples. I'm asking you to trust me. But I think that understanding that helps us understand the complexity, thinking about how we contract with artificial intelligence and using artificial intelligence. So for a long time, we've been making contracts over the internet, right? Basically, we're clicking buttons, we're accepting, we're paying money, we're doing things in absolute real time. But every time the question has arisen as whether there is capacity to enter into that contract, the court's concerned, and I'm only aware of German decisions at this stage, that they've basically looked back to see the humans that sit behind the electronic contracting. So the Frankfurt Higher Regional Court in 2003 dealt with the acceptance of an order that was placed on a web store that was basically declared automatically by the system. And the court classified the automatic declaration of acceptance as a valid declaration of intent, with the reasoning that the software only executes commands that are determined by human programmers. Therefore, according to the court, the automatically generated declaration had its origins in human action, which was initiated by the declarant and therefore originated from the declarant's will. So we met that element of intention. Now, what happens when we have an AI that is making decisions about who it will issue credit to and who it won't on behalf of a bank? A self-learning AI that is making decisions about who the entity that it represents will make contracts with. Now, maybe it's acting as an agent of the bank. Can we still see when a human is providing the credit constraints? Is that enough? All of these questions are really interesting in this context. And I wish I could give you an answer. I really do. But the questions themselves are often more interesting than the answer. And these ideas are going to evolve over time. So that, my friends, is all I have for this video. Questions, concerns, complaints, compliments, you know where to find me. Cheers.